Okay, ladies and gentlemen, so what we've been playing for you right now is the Shawn Grate closing arguments, the prosecution's closing arguments in the Shawn Grate case out of Ohio. I'm Jesse Weber. This is Law and Crime, and also Law and Crime on Sirius XM Radio. What we want to talk about right now, but we'll come back to the Shawn Grate case in a minute, and that's about that accused serial killer who's on trial for 2 murders as well as the abduction and rape of a 3rd woman. We're going to switch gears right now. We want to talk about a new case that's developing. It's out of Florida. It's called the Newman Raja case. It's out of Palm Beach County, Florida. There is going to be a stand your ground hearing where a judge will determine whether manslaughter and attempted murder charges against a former police officer named Newman Raja will be dismissed or whether the case will proceed to trial. The question is, was Mr. Raja justified in shooting a stranded motorist named Corey Jones? And interestingly, this whole encounter was captured on Jones's roadside assistance call. I want to talk a little bit more about this with my special guest right now, criminal defense attorney Richard Tendler. Richard, it's great to see you.
Nice to see you, Jesse.
This case it keeps coming up in the media. I mean, we keep seeing these cases. Another, I should let everybody know, this is a black motorist who's shot by a police officer. But there are interesting, discrete questions here, right, Richard? Whether or not Newman Raja was he identified as a police officer? Was Mr. Jones armed? Can you help explain a little bit more about this?
Yeah, sure, absolutely. This was going to be really interesting because you have an African-American stranded motorist, a police officer working an undercover detail approaches Corey Jones, that's the African-American who was fatally wounded, and he approaches him in a pretty aggressive manner, and according to prosecutors, does not announce himself as a police officer. Corey Jones then has a gun in his vehicle and is startled by the whole thing. Presumably, he pulls his gun out, and then the officer at that point, who has no insignia on him indicating that he's an officer or anything of the sort, fires his firearm, and then the whole thing sets off. So this is very similar in, you know, a lot of these police shootings. The only difference here, the major difference, is that Corey Jones actually was armed. A lot of these police officer shootings that we see around the country, the suspect, the person who was fatally wounded, was not armed. Here, Corey Jones was armed, but then what we have is, you know, an officer, on the other hand, acting pretty aggressively. You know, he was undercover, off duty, and it was just, you know, sort of like the perfect storm, unfortunately, that ended very fatally.
Well, let me ask you this. This is my question. If you have an officer and you present the facts, you have an officer and you have a motorist who's armed, how is that not the end of the day? Isn't that always stand your ground? What are the discrete details here that the defense really wants to put in and say, wait a second, this is justifiable shooting? What does the state want to say, wait a second, he exceeded his authority? Where is that line?
Absolutely, and here's the thing. At the time of the shooting, Corey Jones, the victim, was on the phone with AT&T roadside assistance. He was his car had been stranded. He was trying to get a tow truck driver to tow his vehicle. He's waiting. He's been there for about 45 minutes. That call captured the events and the set of shots that went off. When the officer called 911, according to prosecutors, the officer made it out as if he was actively shooting at the suspect, Corey Jones.
Yeah.
Instead, however, AT&T roadside captures it, and that shooting had already occurred. So that's the difference, and that explains why we have a difference of opinion as to how this went down.
So let's talk about a little bit more. What I have with me, joining me on set right now again, is Law&Crime trial analyst Bob Bianchi. Bob, my question to you now is, and we only have a little bit of time before break, so I just want to ask you real quick, stand your ground hearings in general. How successful are they at dismissing the charges before? Because if they're not successful, this goes to trial, right?
Right.
How successful are they in front of a judge?
It's hard to say. It's very fact-dependent. I don't think it's going to apply in this particular case. It's going to be dismissed. I think a jury is going to make the call because...
Why do you say that?
Because a lot of it requires the reasonableness of the actions. Now, stand your ground doesn't mean, for example, that you get to shoot somebody who's running away and no longer poses a threat. And as the guest has just indicated, there was a lot of funny business going on with that 911 call that seemed to suggest that the officer was manufacturing because they found the weapon about 30 or 40 yards away, and then afterwards there were 3 more additional shots fired at the individual. It clearly wasn't armed, and the officer indicated at the scene that he knew he wasn't armed, that he had dropped his gun at least. So in order to, what I think is interesting, Jesse, to be honest with you, is why when officers are given such broad discretion to use force in their duties, and clearly I agree with your guest, there seems to be over-efficiency here. He wasn't identified as a police officer. He wasn't following protocol and procedure on how to approach that vehicle. In other words, the victim here just actually found that somebody was actually coming upon him. But why stand your ground? And I think the reason for it is, we'll see it as it's fleshed out a little bit, is they want to go with a common self-defense claim that any citizen could bring forward, because then it requires the prosecution to disprove it beyond a reasonable doubt. So I think they kind of want to go on 2 avenues here, the defense. One, that he was justified in doing it as a law enforcement officer, and secondly, even if that was found to be improper, that he's entitled to the stand your ground defense.
We're going to be covering that more here on Law and Crime, and also you can go to lawandcrime.com. We're going to be covering that as well, the Newman Raja case out of Florida. Ladies and gentlemen, we're going to take a quick break, and when we come back, there's a lot to discuss here, including more of the Shawn Grate accused serial killer case out of Ohio. We'll be back in a minute. This is the prosecution's closing argument in the Shawn Grate case out of Ohio. Hi, everybody. I'm Jesse Weber. You're watching Law and Crime, and you're listening to Law and Crime on Sirius XM Radio. The Shawn Grate case, this is about an accused serial killer who was on trial for many crimes, including the murder of 2 women, Elizabeth Griffith and Stacey Hicks, as well as the abduction and rape of a 3rd unidentified woman who's just been named Jane Doe. We want to talk a little bit more about this case because we saw the prosecution's closing arguments, and the case will now be in the hands of the jury. They will have to determine whether or not he is guilty of the crimes alleged. Now, again, I'm here with Law and Crime trial analyst Bob Bianchi. Here's my question. He said earlier in the case, remember, he pled guilty to 15 of the 23 charges. That included the rape of Jane Doe. She testified. He pled guilty to it, and according to him, he said, I didn't want to have to put her through anything more. Really, though, wasn't it to make sure that the rape video, because her rape was captured on footage, on cell phone footage, didn't he just not want the jury to see that?
I'm a little confused by these facts, Jesse. So you can plead guilty to something. Again, I would suggest you don't do it in the middle of a trial. I just think it looks bad. In order to try to prevent certain evidence from coming out because it would no longer be relevant. But I'm not certain that the jury hasn't seen some of these things. That I'm a little confused with, because the prosecutor was referring, to the videos. So listen, it's very compelling evidence, and you see those videos and you see it live. It's going to have a substantial impact if the jury is seeing it and reviewing it. So what I guess the defense is trying to do, like I've had this in a death penalty case, we are trying to exclude the autopsy photos, Judge, because we are not trying to say that he didn't do it. We admit that he did do it, but we have mitigating factors where he should get a life sentence. So if you allow those autopsy photos to come in when we no longer need them in order to prove a homicide case, it will be so overwhelming. This was a case where a woman had gasoline pulled her over and lit her on fire, that the jury will be compelled to give the death penalty. At least that was the argument that was made. And I'll tell you, the judge was coming close to not allowing us to show the autopsy photos to the jury.
Of course, right.
And of course, the autopsy photos were just outright gruesome, and you knew it would have a substantial impact on the jurors.
I'm happy that they didn't see it. I'm happy we didn't see it. As much as we cover the true crime stories here, that's something I don't think anybody really wants to see.
But Jesse, don't you think, I'm sorry just to cut you off real quick, but don't you, this is where I'm confused. If the kidnapping is still in the case, those videos to me are evidence of kidnapping. Kidnapping isn't just that you take a person from one place to another, it's also that you substantially deprive them of their ability to move or go from one place to another. So I still find that they would have been relevant. The judge, if they didn't show the videos, the judge must have said that the probative value was outweighed by the prejudicial effect.
That's an interesting point. That's an interesting point, considering the prosecutor consistently said there is kidnapping here. Even for a minute, when you're restrained, when you're choked, you're held against your will, that's kidnapping. And if you killed her during that, that is aggravated murder.
Right.
That's what kept being said today during the prosecution's closing arguments. What I do want to let our viewers know, though, for the 15 out of the 23 charges that Mr. Grate already pled guilty to, that carries with it 72 years to life in prison. So as we keep talking about here, the main issue for Mr. Grate, it seems like he's going to spend the rest of his life in prison, but will he be sentenced to death? And it seems that his defense team is really fighting against that, because if the jury comes back with those aggravated murder charges guilty, he could face the death penalty. I want to continue playing for you some of the prosecution's closing arguments. Take a look.